Hi, welcome to Shankar IAS Academy. We are going to talk about today's daily current affairs analysis, and today's date is 29/11/2025. Please like, comment, share and subscribe to our YouTube channel. Also hit on the bell icon if you want to receive instant updates. And the topics for today's discussion, the first topic is Ootupurai. Ootupurai is basically feeding homes in temples. And the second topic is the Supreme Court's judgment on user generated content. It talks about how our privacy concerns can be handled. The third one is Chimonobambusa Manipurensis. It is basically a 37,000-year-old bamboo fossil which was found in the Chirag River of Manipur. And the fourth topic, the main topic for the day, is Law Commission's opinion on one nation and one election. And the fifth topic of the day is Prelims Focus. So today's first topic has a strong relation to traditions. Some traditions are prevalent because they're very sacred. Some traditions still pertain because the society has a strong need for them. And some traditions show us who we really are. This is one such tradition which is called as the Ootupurai. So we'll understand what Ootupurai is. Ootupurai is a traditional feeding house in temples of southern Travancore and Kanyakumari. So you can imagine a temple and a feeding house which was associated with it, and the feeding house was called as Ootupura or Ootupurai. The Purai itself means building and Odu means feed. So this is what the purpose was, to provide free meals to the poor. And before 1956, you see Kanyakumari was part of Travancore. Travancore was a place which was prevalent with a lot of problems with relation to caste and other identities. But this system was to be banned in 1922. And why did it get banned? What is the reason? This was not explicitly mentioned, but it was continued even after it was asked to be banned in many temples. One such temple was the Padmanabha Swami temple. So, what is the social and historical significance? Today, we talk about a lot of schemes which are social security nets, like the Annadanam that is given in lot of temples. This acted as a predecessor to all the Annadanams that happened, and it also supported pilgrims. When you talk about pilgrims and the food given to them, there are two types. One is the Ootupurai, the other is the Kanjipurai. So, what is the difference? When something is given to a Brahmin, when some kind of food is given to a Brahmin, it is called as Ootupurai, and when it is given to people of other castes, it's called as Kanjipurai. Here we have to talk about Sri Narayana Guru. Sri Narayana Guru was one such person who talked about one jadi, one madam, and he wanted everything to be one. And this particular person was very strong, and he talked about all the things that were going on in Travancore, and he did not want people to face discrimination based on caste. And he saw this community-led initiative as a kind of positive rebellion, so that people received food and they were not going hungry. Here, the question was only one thing: you can be a traveler, you can be a saint, you can be of any social class, but if you're hungry, people fed you. And there were a lot of North Indian pilgrims also who came to India, and they were called as the Gosais. The Gosais received rice. And we talk about the strong royal backing which was prevalent for this particular scheme. And why did it happen? Because we talk about Lord Curzon, who was not very fond of the situation. He was not very fond of this particular system. He wanted to ban it. So when he went to all the Travancore kings and said that this is absolute mockery, let's ban this particular system. The people were not very fond of what Lord Curzon said, and the kings also took very much offense to what he had said. And one particular king, Moolam Thirumal, he defended the system, and he said that no matter what Curzon says, the system is going to be there because it's a social net for a lot of communities, a lot of people, and we are going to do the system because it is our tradition. Today we talk about a lot of hunger, we talk about a lot of poverty, we talk about a lot of schemes that are prevalent. This charitable tradition was one such thing which was very relatable to the people in the present and the people in the past, because hunger is something that has been very common. There are a lot of temples which maintain these feeding houses. In the example, you see the first temple, the Suchindram temple of the Ootupurai. Why is this very important? Even in an art and culture perspective, if you see, This temple has idol of Vishnu, Brahma and Shiva, and this temple has the idol with all three of them imbibed in them. So it is a trinity idol. So if you have a question on which temple has a trinity idol, you can talk about the Suchindram temple, which was established in 1772. The Tiruvattaru Adikesava Perumal temple also approximately cooked about 600 kgs of rice every day. But Colonel Munro wanted the system to be regularized, and he said that, see, no person can be fed for more than 3 consecutive days. So when this happened, it reduced corruption, it also regularized the administration. But in 1911, a partial discontinuation started. In 1922, as we already saw, we did not know what the reason was, but it was demanded a full closure. But some temples, like the Padmanabha Swami temple, informally still continued this Ootupurai system. And you see, even today, you see words like Kattichoru, Kootanjoru, and all those was very prevalent in the earlier Tamil Nadu. Kattichoru was one place where cooked rice was staff was packed, and it continued till 1966 to help the employees and the local poor. Again, you have to talk about one renowned poet, the Pabanasam Sivan. He worked in Ootupurai in Thiruvananthapuram. He fended for himself, he worked there, and he also wrote a lot of poems. And it had a strong working ethic. Every day had to be grating 100 plus coconuts, cooking, serving, and it was a space for service, livelihood, and temple linked charity. In records, if you imagine, it is predated to the British records. This system is that old. So in 1842, the Sundaram temple had a record where it fed about 86,728 Brahmins in total. So it had physical structures that remain at temples like the Parakai Madhusudana Perumal temple in Tiruvattaru. So the first question of the day is, consider the following statements regarding the Ootupurai or Ootupura system. The Ootupurai system originated as a temple-based feeding practice system in southern Travancore, and acted as a precursor to modern Annadanam schemes. The second is, the British administrator abolished the system in 1922, after which it immediately disappeared from all temples in Travancore. Which of the following statements is or are correct? One only, two only, both one and two, neither one nor two. The Ootupurai system, yes, it originated as a temple-based feeding practice. And the second point, it was asked to have a full closure in 1922, but it was informally continued in a lot of temples, and therefore the correct answer will be one only. Let's move on to the next topic. The next topic of the day is about user generated content. Internet has not only become a place for a lot of ideas, it's also become a place for a lot of misinformation. And with this information era, the Supreme Court asks the government to regulate content on the internet. So the Supreme Court has asked the Ministry of Information and Broadcasting to frame guidelines for user generated content. In relation to this, we will see what user generated content on internet means. The user generated content refers to any content, text or image or videos, or review, memes, audios, social posts, etc. So it is basically uploaded by common man. It is not by media houses, not by journalists, not by any regulatory authority, but it's by normal people. They generate content and they upload it. In today's scenario, content generation and content curators have become prominent people, and they are very famous on YouTube and Instagram based platforms, and they create content to generate ideas and they give out opinions. So these are published on digital platforms, as we already mentioned. What is one of the key feature here is that everyone has a voice, everyone can give an opinion. You can just tweet, you can just write a blog or anything that you feel. You have your own voice, but in that case, do you have editorial checks? No. That is what the third point here mentions. And when you don't have editorial checks, and when you don't have somebody to tell what is right and what is wrong, it can go very viral quickly. So user generated content has that one risk, that it can go viral very quickly. and it is interactive and participatory. You can talk about the Instagram lives that celebrities use or content creators use, and a lot of common people like us, we ask questions and we participate, we give out our opinions, and it is a cumulative effort. So when you have a higher view base and you have a higher subscription base, this happens. And the first risk is of misinformation and fake news. When we talk about misinformation and fake news, we can all remember the 2023 Manipur violence, where we had a lot of issues wherein there were a lot of fake videos that were curated online. There was a lot of fake news, and we used to see all this. And we can also remember when there is some renowned person who's admitted in the hospital, and if it is some chief minister, or if it is some prime minister, or if it's somebody of that importance, we see a lot of news channels who want to give out the first news. And in this case, if we draw a parallel to common man, we also want to give some information that only we can do. We want a unique selling point. So we just give out a fake news about something that is primarily important. Take the case of COVID 19. During COVID 19, all of them had a lot of opinions to say. They gave in their old antique grandma's medicine. They gave in their own ideas on what to be done during COVID, their own preventive measures, and a lot of it was not even scientifically tested. So we can draw a parallel about what media houses are doing and what fake news is happening with user generated content. It is also to do with hate speech and abusive content. When you don't like a particular community of people, you start a hate speech, and there is a communal war which is going on online. And this abusive content not only hinders people of that particular community, but also affects the secularist ideal of India as a whole. We also talk about obscenity and privacy violations. Recently, you can also witness that our former Miss World 2004, Aishwarya Rai, had mentioned that she had her deep fakes which was going viral, and she did not want that kind of obscenity online, and it violated her privacy, which is very true. Today we have a lot of deep fakes that are circulating, and it is available to common man. You talk about OpenAI, you talk about DeepSeek, you talk about a lot of platforms which can help you make deep fakes. And when these deep fakes come into play, you have a lot of defamation and reputational harm that happens not only to people and not only to people but also to media institutions. There are a lot of security issues like radicalization. When something radical goes out with user generated content, the question is, who is accountable? You can ask them to take it down, but do you have a guideline? How is it accountable? Who is accountable? And this is what the last point is about, the lack of accountability for creators. Now there are a lot of legal provisions for online content regulation. The IT Act 2000 is one wherein it addresses the cyber crimes and unlawful online content. So when you give a lot of police cases, this IT Act comes in when it is a cyber crime case. The IT Rules 2021 also, it talks about how social media platform remove illegal content very quickly. And the DPDP Act of 2023 talks about personal data and penalties. So non-consensual deepfakes, when that happens, how do they punish it? How do they penalize it? Is what happens here. And the BNS 2023 punishes misinformation, defamation, causing public harm. So these are some of the legal provisions: the IT Act 2000, the IT Rules 2021, the DPDP Act 2023, and the BNS 2023. So clear points from the Supreme Court. Let us understand one thing. The Supreme Court is asking for a balance. The Supreme Court is not saying that you have to completely forgo your Article 19, that is freedom of speech. It's just saying that you can have freedom of speech, but you should also have accountability. When you talk about accountability, we have to frame clear rules to curb these defamatory, harmful online content, and it wants to create an independent authority for regularizing and overseeing the content. It wants to provide protection for victims, not just asking them to take the content down, but they want to protect actual protection to victims. They want to have faster takedown mechanisms. They want to introduce age verification for adult content, because today mobile phones are a necessity. A lot of people have them, and even youngsters, even a child of 5-year-old child is taking a phone and uploading content. She becomes a content creator on YouTube. So today we need to have age verification. And with respect to free speech safeguards, we have to have a balance, and we have to strengthen protection against online abuse. Consider the following statements regarding the Digital Personal Data Protection DPDP Act 2023. The Data Protection Board of India is responsible for enforcing and adjudicating data protection related violations under the Act. Individuals have the right to withdraw consent for processing their personal data at any time. Which of the following statements above are correct? Yes, the Data Protection Board of India is responsible for the data protection and violations, and also individuals have the right to withdraw their consent for their personal data at any time. So the right answer will be both 1 and 2. Let's move on to the next topic. So today we are going to talk about the second topic, which has rewritten India's botanical history. It comes from Manipur's river, the Chirang River, which reveals India's ice age secret. And this, what is the secret? We have found out a 37-year-old bamboo from Manipur's Chirang River. So this was discovered in Impal Valley of Manipur, and the scientific name of bamboo is Chimonobambusa Manipurensis. So the research was conducted by a group of scientists, and the group of scientists belonged to the Birbal Sahini Institute of Paleosciences. Birbal Sahini Institute of Paleosciences. Why is this fossil very important, and why has it rewritten India's botanical history? See, usually bamboo has no geographical track record. What do I mean by geographical track record is that bamboo has a tendency to decay very quickly, and as it decays very quickly, it does not have a lot of fossil evidence. This bamboo is the earliest fossil evidence of a thorny bamboo. So usually bamboos do not have that much of thorns in Asia. This shows that the bamboo has evolved. So as we talk about Darwin's theory of evolution, and we talk about how giraffes' necks elongated, or how we became humans from apes, and how we civilized, and how certain monkeys did not have tails, we have a lot of talk about how evolution happened. It shows that the bamboo 37,000 years ago had evolved from having thorns. So why did they have thorns? Thorns were a protective mechanism, the protection against herbivores during the ice age, because they used to eat a lot of bamboos. And bamboo fossils are rare, as I already told, because they decay very quickly and their stems are very hollow. Hollow in the sense, you see, this is how it is hollow, and here you have a very hollow thing, and it is very fibrous. So finding a fossil with preserved nodes, buds and thorn scars is extremely unusual, and India has become the ice age refugee. Why do we talk about refugee? Because earlier, during the ice age, bamboo was also prevalent in parts like Europe. But after that, during the ice age, the drier conditions, the colder air, everything wiped the bamboo civilization out of Europe, and as a refugee, it came to our Northeast India. The Northeast India remained warm, humid, and it gave a completely safe space, a safe refugee where bamboo could thrive and survive. So we became places where bamboo could survive, and bamboo's family started growing here. This is the fossil evidence that was found, and it had well preserved nodes. If you can see, you can even see the hollow parts that are in this image. So bamboo is a fast growing grass. It is a subfamily of Bambusoideae. It can grow up to 90 meters a day, and some species can grow even up to 90 meters a day. So this is one of the fastest growing plants on earth. It is also called as green gold. So this can be a prelims pointer question, wherein if they ask about what is mentioned as green gold and bamboo is the option, you can give bamboo as the option. India is the second largest producer of bamboo. You can use this as a data point in some answer. And yes, this is bamboo. You see this hollow stem. Earlier this was also used to collect paper resins. From this system originated, and this hollow stem is used to create resins which was used to make paper as well, and you get a lot of musical instruments also made out of bamboo, and this hollow nature contributes to it. So again, one other use that you can talk about when you're writing your answers. And we are talking about the National Bamboo Mission, which was restructured in 2017 and 18. This National Bamboo Mission is a centrally sponsored scheme, and this is for the development of the bamboo sector. So this comes under the Ministry of Agriculture and Farmers Welfare. If we talk about the objectives, it is not just to promote bamboo cultivation. Yes, it is an objective. Let us promote bamboo cultivation. But apart from that, it is also to strengthen the value chain of how bamboo is transported, the logistics, and to import the imports should not be high, so they wanted to reduce the import dependence. That is one of the point, and it wanted to improve the livelihood of farmers and artisans. The last topic, the main topic for the day, is Law Commission's view on one nation, one election. If we take the case of India, everybody is voting somewhere every month. But let's imagine a different India where everybody has one nationwide mass drill. Everybody votes on the same day and everybody votes with the same agenda to have our representative. That is one nation, one election for you. And we are talking about how the basic structure doctrine is not violated with the one nation, one election bill. The context of the news is that basically the Law Commission has given out its opinion on what its idea is on the one nation, one election bill. And this Law Commission is the 23rd Law Commission. And there is a joint committee of the Parliament that has two important people there. One is the people of the Law Commission, one is the people of the Election Commission, and they're going to have a joint committee on 4th December 2025 to discuss on this pertaining matter. So what are the key findings of the Law Commission is that, see, there are a lot of bills which affect the basic structure, but they're saying that this one nation, one election bill is not one such bill, because it ensures that you have the right to vote, it ensures that we have free and fair election, and it ensures that your federalism is maintained. However, here we can talk about a threat that although we have federalism, due to the over influence of the centralizing tendency that is there with this bill, states might lose their autonomy if it is not used properly. So that there is a chance. This bill only affects the duration or frequency of the election, but it does not influence the right to vote itself. This is one important mains pointer that we can use in any answer that is asked about the one nation, one election bill, because the right to vote is still intact. Now, no state ratification is required. In a lot of cases, we need state ratifications. Why state ratification is not required is that this bill does not amend any of the article. The article 54-55 president election, 73-162 executive power of union or states, 124 to 147 the Supreme Court, 214 to 231 the High Court, 328 to 329 the election matters. The bill does not amend any of these, so the state ratification is not required. The provisions of the one nation, one election bill is basically the synchronization of elections, as in a new India wherein from Kashmir to Kanyakumari we will all be voting on the same day, like a national drill. And the Lok Sabha and all the state assemblies will be aligned by curtailing terms of the state assemblies, and it will be elected after the Lok Sabha election. Once it is synchronized, we have simultaneous elections every 5 years. So here we have to note a point that over 50% of the VVPAT machines are idle most of the year, and they are used only when the elections come in. So this can be one format wherein all the VVPAT machines can be used at one point. We can reduce the financial cost, we can use proper resources, and it would help us to have the provisions of one nation, one election bill put to good use. And the Commission's view is that, as earlier mentioned, it saves time and money, it reduces the administrative burden, and it does not affect accountability. The parliamentary democracy is ensured, and the government remains answerable till the last day. So this one nation one election bill is not something new. From 1950s to 1967, actually this bill was to be passed, but we had a lot of other commitments which made it difficult to be handled. The Law Commission stand on model code of conduct. So there was no statutory backing. It should not be codified into laws, and it would slow down decision making during elections. Why? Because if we have a codified laws, we should abide by it. But this is basically based on your gut instinct, so that it can be flexible, moral, and convention based, allowing quick action. If not, if it is codified, you would have to abide by all the rules, and it would make decision making so slow. So, this model code of conduct is enforced by the Election Commission of India under Article 324. It is non-statutory, but it is binding by convention. It restricts the misuse of official machinery, and it applies from date of election to announcement. Law Commission also opposes adopting Germany's model. Here are the reasons. Because it requires proposing a new PM before ousting the current one, which cannot happen. And the Commission states that the current mechanism under Article 75(3) is not suited to Indian parliamentary dynamics. The basic structure doctrine evolved from the Kesavananda Bharati case, as we all know, and the Parliament can amend the constitution, but it cannot alter the basic structure, which is what came out of the Kesavananda Bharati case versus Union of India in 1973. So elements that are related to this issue is federalism, democracy, free and fair elections, rule of law, and judicial review. The Law Commission is not a constitutional or statutory body. It is basically an executive body. It was established in 1955. The functions are legal reforms, reviewing outdated laws, recommending repeal, and drafting bills. The 23rd Law Commission also talks about this. The Moral Code of Conduct was first given in 1960s in Kerala. Kerala is one of the states where they have uniform elections when it comes to their own state elections, and this is adopted nationally from the 1968 Lok Sabha elections. There are types, that is general conduct, polling day, meetings, observers, processions, party in power. These moral code of conduct are not legally enforceable, but Election Commission of India uses Article 324 for enforcement if needed. The mains practice question for the day is: the proposal for one nation, one election seeks to enhance governance efficiency but raises complex constitutional, federal, and logistical concerns. Critically analyze. So, this question should be approached in the basis that you have to separate the one nation, one election. In a governance perspective, you have to split the constitutional concern, the federal concern, and then the logistical concern, and then you have to give a critique for half a page in the end, and that way your mains practice question will have a holistic coverage. And after this, you can send answer copies to us directly, and we would provide comments for your questions in the comment section or in the place where you have uploaded. So we hope you have a good feedback with this. So the next topic for the day is based on Prelims Focus, the Telecommunication Cyber Security Rules 2025. So basically the department that is associated with it is the Department of Telecommunications and the Ministry of Communications. So what is the aim of this Telecommunication Cyber Security Rule 2025? It is built on the 2024 TCS rules, but it also has a higher potential to preserve the digital ecosystem against all the telecom frauds. Today we see a lot of telecom frauds that are happening, and it is trying to strengthen the traceability of people who are using telecommunication, and it is to ensure that the telecom users are easily identifiable. So what have they done for that? The new frameworks have come in. That is, the first one is mobile number validation platform. That is, if you have a mobile number, they are going to check if the mobile number really belongs to you. So that is mobile number validation. Resale device scrubbing. So when you are reselling a device, they are going to check if your IMEI number is blocked or blacklisted or belongs to somebody else. That is the second. And the third one is telecom identifier user entity obligations. That is, if you are going to log in into any OTT platform or Swiggy, Zomato, Ola, it also takes in that this is the user and it is registered to this particular person. It is also going to take the data to ensure that you are a legitimate person. So the significance is that it marks that we are future ready telecom people with a strong cyber security framework, so that we balance all the innovation that is happening today with our national security. We are forming a strong grid in that. The next topic is turning geranium waste into biochar. So geranium leaf has a waste which comes both from pre and post oil extraction, which is mostly discarded as a byproduct. But now it can be a value added material. It is done by researchers in the University of Hyderabad, and it is determined to transform geranium plant material to biochar. So biochar is basically a carbon rich product. It will improve the soil and it stores carbon. So biochar has about 65% of carbon, and when you use this biochar with plants, the nutrient uptake is high. So the advantages is low cost, it is energy efficient, it makes it attractive for farmers, and it could reduce the environmental impact, and it could cut production costs. And we talk about a lot of circular economy. This will promote a circular bioeconomy where we improve crop yields across many regions in India. So biochar is basically an organic material. It is produced through this pyrolysis, a process which has the use of heat, and through this heating the inorganic matter dies, and the key steps of production are feedstock selection, pyrolysis, cooling and collection, and application. Pyrolysis occurs at high temperatures and it transforms the biomass into a charred substance. Basically the substance dies, and in historical context, even thousands of years ago, it is most notable that it is used in the Amazon basin as a historical application, and a lot of indigenous tribes created this ideal for soil fertility, wherein it was called as terra preta or black earth, basically adding charcoal to the soil. The next question for the day is, what is the use of biochar in farming? Biochar can be used as a part of growing medium in vertical farming. When biochar is a part of the growing medium, it promotes the growth of nitrogen fixing microorganism. When biochar is a part of the growing medium, it enables the growing medium to retain water for a long time. So which of the statements given above are correct? So the first point, yes, it is a growing medium in the vertical farming. The second point, it is a part of the growing medium. Yes, it promotes nitrogen fixing microorganisms. And the third point, yes, it retains water for a long time. It makes the soil fertile. So when we ask about which of the statements are correct, the option will be 1, 2 and 3. This is a UPSC 2020 previous year question. Please like, comment, share and subscribe to our YouTube channel, and also hit the bell icon to receive instant updates on notifications. Hope you have a wonderful day, and thank you for watching us.